You heard the utter disbelief at Donald Trump's presidential immunity argument when Trump's lawyers made their case last month to the federal appeals court. And that was from the lone Republican-nominated judge on the three-judge panel, Judge Karen Henderson. Today, Henderson's line was featured almost word for word in the filing issued by that panel, which delivered a massive blow to the twice-impeached, four-times indicted former president. In a 3-0 ruling, the judges found that Trump is not immune from prosecution for acts committed while in office, a defense he has used, or he's attempted to use, to dismiss the federal election interference case against him brought by the special counsel Jack Smith. The appeals court judges argue that Trump, like every other American, is bound by the law. To say that Trump or any president is above the law strikes at the heart of the American experiment, they say. They write, quote, at bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that as to the president, the Congress could not legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. So now begins a race against the clock. The former president has already indicated that he will appeal this decision, which he has until next Monday to do. The appeal will go to the United States Supreme Court, making this yet another issue of Trump's candidacy that the high court will have to consider. 2 days from now, arguments will begin over whether the former president violated the Constitution with his behavior around January the 6th. A case we will discuss just a little later this hour with Judge Michael Luttig. But what the Supreme Court decides with today's ruling on impunity will have huge implications for accountability. If the High Court acts quickly, there is a chance Smith's election interference case can go to trial before the presidential election in November. And that's where we start this hour with the Congresswoman Madeleine Dean of Pennsylvania. Plus, with me at the table is MSNBC's legal analyst Lisa Rubin, and MSNBC chief legal correspondent and host of The Beat, Ari Melber. A rare occasion to be in the same place with you, Ari.
Very happy to be with everyone,
nice
in person and on remote. Thank you.
And Congresswoman Dean, when I am in Pennsylvania, she is my member of Congress, so it's good to see you again, Congresswoman. Let me start with you. Let's start with the big picture first, as opposed to the legal picture. The big picture here is that the legal argument, most experts, and I'm sure Ari will back this up, was always a little bit weak to start with. It was a political argument. Donald Trump felt that he should somehow frame within a legal context the idea that he doesn't want to be prosecuted for things he did as president. This now moves it into the realm of accountability. There's no trial yet, but Donald Trump can now be tried for things he is accused of doing.
Well, it's good to be with all of you, and I'm honored to be your member of Congress. I have to tell you that, remember where this case began. It began August of last year, where the federal grand jury charged Donald Trump in connection with his actions, criminal conspiracies to stay in office, whether it was to try to rid millions of people of their vote, whether it was to obstruct the official proceeding here, as you know, on January the 6th, the counting of the electors and certification of that. And so what this court did, and I think with great clarity, you pointed out some of it, is to say, no, you are not entitled to some sort of special presidential immunity from crimes you commit while you are in office. It would turn our system upside down, or, as you say, collapse it. One of the best lines that I saw as I skimmed the 57-page opinion, the three-judge panel said, today we affirm the lower court's denial of the grant of immunity. For the purpose of this criminal case, former President Trump has become Citizen Trump, with all the defenses of any other criminal defendant. He is neither above the law, nor is he beneath the law. He stands as Citizen Trump.
I agree with you. That stood out to me. And of course, you mentioned the decision which you brought with you as a printout. What stands out to you in there?
This decision, which is historic, it is now a precedent. It could be, as you and others have pointed out, reviewed by the Supreme Court, or they might just let it stand. And it says, for the first time ever, at an appeals court level, that a former president can not only be put on trial, which I think most lawyers knew, that's why Nixon took the pardon, but can even be put on trial for alleged conduct or activities in office that may have so thoroughly and clearly cross the line, that they are criminal in nature and not part of being president. That's a big deal. And so I think what jumps out to me is that this was written in a way to stand. It is very detailed. It has long sections on jurisdiction, other issues. It is trying to say in a way to the Supreme Court, we got this. Obviously, sooner or later, you might review this. If there was a conviction, a post-conviction review would be standard. There have been politicians who've been spared by that process, and this defendant, like any, is afforded that. But they seem to be saying, maybe just let the case go forward from here. Let Jack Smith try this case, because it's written in a very thorough, clear, and fair way.
So is it your sense, Lisa, that there are various options as to where this can go next? This doesn't just immediately move to trial, although Tanya Chutkan is now thinking about when that trial is going to be. What are the possibilities for what happens immediately now?
I mean, it could be anything, Allie, from a very swift denial of even Supreme Court review by that court to the court holding on to briefing on whether to grant review for several months. And that's what I call the Gerstein option after Josh Gerstein of Politico, who warned last week that the longer it took the D.C. Circuit to render this opinion, it may be that they were giving the Supreme Court an excuse to hold this case over until the next term of the court. As Ari well knows, the terms of the Supreme Court run roughly from October, the first Monday in October, to the very end of June. And of course, they do some work during the summer months. But if they were to hold it over until the next term, that would effectively mean no oral argument until next October. That makes the possibility of a trial prior to the election an absolute nullity.
Congresswoman, one of the things that the Trump legal team argued before the court was that if you do this, if you do not allow the president to have this immunity, presidents are just going to it's going to grind to a halt everything the presidents do, because they're just going to constantly be worried about if they lose the next election, the new president will prosecute them. In it, there were two flaws. One is the idea that this is a prosecution by a new administration against a former administration, but more importantly, this court deemed in its decision that, in fact, being able to hold a president liable for crimes committed that are not part of the execution of his duties would be a positive incentive. That would actually, presidents should look over their shoulders if they're going to commit a crime in office.
Well, think about it. We've run this country for almost 250 years. Have you ever heard a candidate for president or a sitting president or a former president say, yes, I want to run on the basis that I'll be immune from any crimes that I commit should you elect me? It's an absurdity on its face. Of course, we have not ground to a halt. Former presidential work has not ground to a halt because you're actually held to account. You're held to the law. That is exactly what should happen. We had a president resign because he was unable to uphold the law. So I find it just an absurdity, and that's what I'd like citizens to know. Beyond all the legal isms around this is literally a candidate for president who is trying to run for president by saying, when I'm president again, I want to be and believe I should be immune from any criminal prosecution. We're right back to I could shoot somebody on Fifth Avenue.
Yes, or in the case of this particular trial, Ari, Navy SEAL, SEAL Team 6 can be sent to murder someone. Donald Trump put out a post today on Truth Social. It's long and involved and has capitalizations where there shouldn't be any. But the last three words are all caps. Save presidential immunity. Like, that's become the thing, that now it's not just whether I'm on trial or not, but now presidential immunity is a thing that requires being saved because the Biden administration and this corrupt court decided that he's not immune from this.
Yeah, I think it's hard to take that seriously. As a criminal defendant, he's afforded many rights, and those include being legally presumed innocent. So it's a very long road and high bar. But no, you don't really want to have immunity for someone with those level of powers even after they leave office. And to remind everyone, no one is saying here, for example, that a sitting president who orders a military operation that goes wrong is going to be tried the next day for murder, and thus they cannot prosecute war powers. We're nowhere near any of that. It's not that movie. It's the situation that Nixon was in, which is when you abused your powers not on behalf of a good faith but mistaken act for the country, say national security and war or the border, but rather on your own political benefit because you are trying to distort or end democracy. I mean, you remember, the things that get people in most trouble, Nixon and Trump, are at least the credible evidence, accusation of abusing power to stay in power.
Right.
And in many
Right.
parts of the world, that works. That is effective. It didn't work for Nixon, and as we all remember, with much a heartache and some loss of life, it didn't work for Trump in 2021. But that's what this is about. And so I think that the ruling reminds you how weak those arguments are of total, endless, absolute immunity. Nixon didn't think he had it, which is why he took the pardon. And Trump's lawyers said he didn't have it when they were defending the case. And that was cited in this ruling.
You made that point a couple times about Nixon. If there was a certainty of presidential immunity for the things that you described, why would Nixon need a pardon?
Absolutely. I mean, I'll give you a very different, quick example. There is an international court at The Hague. They have tried people in absentia, et cetera. Most American figures, generals and others, forget the president, don't take the position they need a pardon from The Hague. They take the position that they're not answerable to The Hague. Now, you could debate it or not, but you don't take a pardon you don't need, that's their legal position. And the DOJ, under both parties, by the way, has held that position that, no, you're not answerable to a foreign court. So here is the opposite. Nixon took the pardon. Others have negotiated. I mean, this is all pretty standard. And I think the Supreme Court question, which, again, we're in the news, so we jump ahead. When this news broke, I posted, in addition to turning on MSNBC, and people immediately said, OK, so what's SCOTUS going to do? Short answer is we don't know. Right. But the lens for that is it only takes 4 votes to hear this thing and slow it down. And so the question is, are there 4 people on the Supreme Court who think the best thing to do with this clear resolution now offered is to walk it back and slow it down before there's even a trial?
Exactly right. And that